Hi everyone, my name is Ali Davis, founder of MediatorAcademy.com, home of the passionate mediator. This is where we interview the very best mediators and thought leaders from right around the world. We learn about new opportunities in the field of mediation, as well as how to overcome some of the challenges and dilemmas we sometimes face. Okay, the big question for this interview is this. How do we reconcile the need for accountability in mediation with the core principles of confidentiality and flexibility? And what role could technology play in helping resolve this dilemma? My guest today is a senior lecturer at the Faculty of Law at the University of Haifa in Tel Aviv. Her areas of expertise are ADR, ODR and civil procedure, with research focusing on the relationship between formal and informal justice systems, dispute resolution system design and the impact of technology on dispute resolution. She's a fellow of the Haifa Forum of Law and Society, the Haifa Center for Law and Technology, and the Center for Information Technology and Dispute Resolution at UMass Amherst. She holds a doctorate in law degree from Columbia University and was admitted to the bar in Israel in 1998 and in New York 2001, and was a certified mediator in New York. It's a real pleasure to welcome once again Orna Rabinovich Interview onto Mediator Academy. Orna, welcome.
Thank you. My pleasure. Good to be here.
Good to have you on again. That's fantastic. Okay, look, let's start with the problem that we have in the field of mediation. And I'll start with offline mediation.
Right.
And that is accountability, or should I say the absence of accountability. Say a little bit more about the problem, Orna.
Okay. I think first of all, it's important to recognize that there is a problem. I'm not sure everyone would hop on board and agree to the existence of the problem. So I think an important step is to actually name it as a problem. Mm-hmm. And I do think there is an accountability problem in mediation, potentially in other ADR processes as well. And this problem has seemed for a long time as an insoluble problem, as part of what mediation and ADR are. You know, they come with their great advantages and their great appeal, but the cost is a cost to accountability. And for many of the proponents, this was an accepted fact. And for many of the opponents, this was exactly why they opposed it, right? Because you can't know what's going on in that room because it's so flexible. Any mediator can do whatever they want. It's very hard for the parties to actually reflect upon what happened in the room and to realize, even if they are aware of what happened in the room, that something inappropriate took place in the room, or things could have been performed better, or there was a juncture in which a mediator actually made a decision, but that decision was made in his or her head, and the parties don't even know what the other options would have been for the mediator to do in that situation. So the whole concept of having this very flexible, intimate process that takes place within a closed room, behind closed doors, where very little information is gathered and preserved about what actually took place, is really why this process is both so wonderful and so problematic at the very same time. Okay, so what I termed in my writing, in my earlier writing, as the accountability dilemma is that precisely the qualities that make mediation so attractive, its confidentiality and flexibility, are also what stand in the way of reaching accountability, at least in the way we've been accustomed to thinking about accountability, in the way we do so in court, right? How do we reach accountability in court? How do we ensure that judges are accountable? Well, we have our way of doing it. We have everything, it takes place in the open. We have clear pre-existing rules for judges, how to conduct themselves, how to conduct the trial, how to intervene. If they don't do it, we may have them removed from the case, right? We may have them turned over in appeal. We have various other measures for making sure that they actually act the way they're supposed to act, and to make sure that the process is equitable, is fair, meets certain standards we expect of it.
Yeah.
And many of these measures just cannot be implemented as is in the mediation setting. Yeah. So there we have a problem. Now, what some people say is, wait a minute, Orna, you're confused. This is very, very different, right? We don't have a judge here. We have a mediator, and the parties are the ones who decide what's going to happen. The mediator just facilitates the conversation. And then they say it's not dangerous. There's no accountability dilemma. Of course, we have to know that the mediator is competent, it follows the procedural guidelines, but it's not as risky as a judge. And there, I have to say, I disagree. I think that informal power is also power, and I think that a mediator, anyone who's mediated, I think knows they have a lot of power in the room, and they could abuse it, and they could be incompetent and lead to bad results. I think informal power in many ways may be more dangerous than formal power.
Yeah, so we've got the sort of intentional bad practice and unintentional bad practice, when someone might be motivated by the result and getting the result and incentivized to get a result in some way. And somebody might just be, not know that they're absolutely stuffing the conversation up, or their unconscious bias is having some kind of influence over the parties, or they're steering the conversation in a particular direction based on their own agenda, but not very subtly.
I would see that as the core problem. I don't think the intentional problematic behavior is very pervasive. I would think that the prevalent problems are those where people may be incompetent, may be not unaware.
But I read your paper, Orna. It's a brilliant paper, and I think there's a bigger thing, and you alluded to it in your paper, and I think actually by having this sort of confidentiality, this secrecy, this cloak, it actually deprives mediators of the opportunity of learning, developing, and growing, right? And improving their effectiveness. I think that's a huge thing. How do we learn and grow and develop and improve and learn from our experiences? I could probably, if I'd video recorded all of my mediations, I'm sure there are half a dozen things at the very least that I could have done differently, better, with the benefit of somebody else giving me some feedback or just challenging. Why did you say that then? Why did you do that then? Why didn't you do this?
And that's natural, obviously. We're not creating robots here, but so naturally that could happen, and that will happen. Yeah. But I think we're talking about opportunities for self-reflection and improvement and learning. Definitely, that's a major point. Learning on the individual level as an ADR practitioner or ODR, if we reach that, and learning on an institutional level. Yeah. If there's an ADR provider, we're talking about ODR as well. So if there's a provider of mediation services, I think that group of individuals would also want to know what's taking place within under its auspices and further best practices,
and also to develop the field of mediation.
Certainly,
it's a new field to develop that sort of
certainly. And if you think of there are so many questions that run through the field, questions about best practices, about mediation schools. Are certain schools, should certain schools be ruled out? Is evaluative mediation? Should it be used in certain contexts? Should parties have mandatory legal representation in certain contexts? Should we have co-mediation versus single mediators? Should we mandate co-mediation in certain areas? Perhaps in family mediation, we want to have a mediator who has legal background and a mediator who has therapeutic background. I mean, there's been so many suggestions out there and very little empirical knowledge on what goes on, to a large extent because of confidentiality measures, and I would say to overly extensive understanding of what confidentiality means and to what extent it is important to the parties themselves. So part of what I question is, have we just become so accustomed? Is it easier for us to just say it's all confidential, we're not dealing with it? And you know what, maybe we're actually kind of happy with people not looking over our shoulders. I know that when, sometimes people want to videotape my class, I'd rather know what's going on, right? So there's also this sense of it may be easier to continue doing things this way, but I think we're definitely missing out as a field and as practitioners when we do that.
Yeah, so one assumption that might need to be challenged is the idea of confidentiality, why that is absolutely paramount. I mean, because it may be the case that it isn't necessary. I don't know.
Right. I think in certain contexts, it actually serves certain parties, sometimes the powerful parties, not necessarily those we want to protect, and may actually be abused. Yeah. And I'm not sure we want to help that. We want to assist that. In other contexts, what I try to promote in my writing is a more nuanced understanding of confidentiality. It's not either or. It's not either we have confidentiality or we don't. And when we have confidentiality, it doesn't have to match the understanding of confidentiality we've held up until now, which means nothing is preserved. Yeah. I take notes as a mediator, but I'll destroy them later, right? Why? Maybe I don't have to destroy them later. Maybe I should actually keep them. How often are mediator notes subpoenaed? There's a research project. I don't think that very often. I think actually that very rarely. I'm saying this without having examined the question. But I think we're losing out. What we're losing out is much greater than the risks we would be taking by preserving some of this information. Yeah,
whenever I say that in a mediation, I'll be taking notes, but I'll be destroying them. I have an image of me in front of a big furnace, where I destroy all my mediation notes, And
the parties are probably like, okay, who wants to destroy them? Okay. Yeah. But, I'm not sure they're that sensitive, certainly not in certain contexts, okay? So it's a question.
Yeah. So what are the existing accountability measures in mediation?
Right. So, we have standards as to what type of training a mediator should undergo. Typically limited certification requirements depending on, various jurisdictions. Various ADR providers would set their own sort of additional layer of requirements. Some ADR providers may require their mediators to undergo annual training. I would say that's rare, but some do, and I think that's obviously a good measure. Some in certifying their own group of mediators would require, for example, a videotape simulation and an analysis. Some wouldn't. Some would require you to undergo that annually, which I think is actually a good idea. Some may have observers sit in the first 5, 10, or 20 mediations. Some would have additional training requirements for specific fields. Yeah. And then in terms of after the fact, of ex post accountability measures, they would typically follow how many settlements have been reached, which I think is a very poor indicator of quality. I'm actually very concerned when I hear very high a high rate of agreements reached. I'm worried about coercion. I'm worried about what types of tactics these mediators employ. When I hear it's around the 50, 60, I'm typically happier than 90 or 95, okay? It depends, again, you never know, but I think that could actually serve as a sort of cautionary indicator.
What leads you to feel suspicious or be suspicious about high rates of, is that data driven, or is that a sense, or something else?
Well, I think, and I'm saying this very loosely, but from the various research I've read over the years, your sort of typical settlement rates, normal rates would be around 60. Anywhere between 50 and 70 is sort of normal. Yeah. Above 90, I worry, and I worry both because it's not within the scope that you typically hear about, and I have to say, this project stems from a personal experience. I always tell my students, in my training, one of my mentors was a bad mediator. So I actually think I learned more than if I had been with someone who was very good. And it drove my research agenda afterwards. Wow. Just having been exposed to that. So part of my training during the mediation training was to sit in on mediations, and I have to say, the mediation provider actually responded very well to the feedback that I raised together with my fellow trainee.
Yeah.
And what we saw there actually colored much of my research. If we hadn't spoken, that would have stayed in that room.
Yeah.
And I felt that what took place was very powerful and abusive, and impacted people who were disempowered.
Yeah.
So that really, I saw how ineffective the typical measures we follow were in that case, how even the satisfaction forms that the parties might have filled or might not have filled, I don't think they would have uncovered what took place in that room.
Yeah. And I suppose the thinking about the satisfaction forms, that's assuming that the parties are informed buyers of mediation services, that they really understand the difference between the different practices of mediation. They really understand the notion of self-determination, what that really means, and what.
Right.
And of course they're right in the heat of the dispute, aren't they? So they're not going to be thinking about, the mediator said something, I wonder if that's consistent or inconsistent with. That's not what they're going to be thinking about.
So I'm not saying they're that we don't need them at all. Yeah. They're not redundant, okay? But I do say they're certainly insufficient as a measure. So I certainly would want to hear how parties felt. Did they feel that the mediator listened to them? In what way did they feel the mediator helped them? Yeah. And it certainly would reflect something about the process, but I'm sure they missed a lot. They were busy being angry for probably at least the first half of the mediation, right? And they're thinking about what they need to do, what their options are. Very, very difficult to count on them as sole evaluators of the process and of the competence of the mediator. Yeah, I agree. So that's definitely an important measure. It should be there, but we should think of additional measures that would provide also some kind of a more external evaluation of what took place. And I think this is becoming all the more important as mediation becomes such an inherent part of our justice system. Yeah. So obviously I wouldn't want people to be taken advantage of anywhere or be abused in any context, yeah. But if we're taking people who filed a lawsuit or would like to file a lawsuit, and we're actively referring them as the state, as the justice system, to sit in a room with a mediator, we have to ensure that they receive high-quality services, yeah. That are fair and effective and meet a standard that we feel comfortable with.
Yeah, agreed, absolutely agreed. Okay, so that's the problem. Where have you got to with your thinking? Because your thinking has been influenced by your personal experience, and of course your interest in ODR and right. Technology, and how technology can be used to scale access to justice and so on. Where's your thinking right now? How can we use technology? What lessons can we learn from technology to help improve accountability in offline mediation, as well as how it's currently being done in online mediation? Right.
So I think, in a way, what I've written has become all the more true. Because in offline settings as well, we employ technology. I don't think there's any mediation center that doesn't store its file, information about its files in a digital form nowadays. Actually, when I was training, they had a lot of paper. I'm sure that today that's virtually non-existent. Yeah. And this actually makes learning and monitoring much easier, even if the mediation itself takes place face-to-face, because you have a lot of data. You can store it in one place, and then you can cross-check the data and see if anything comes up. But what's important, I started thinking about these issues because initially this was perceived as the big disadvantage of online dispute resolution. Everyone was like, yeah, but you can't ensure confidentiality. Everything is documented. Everything is written. And then you would say, yeah, but see how it works on eBay. And they would say, yeah, but those are eBay disputes. And then you would say, well, actually, people really like it in family disputes as well. And then, that got me thinking, is this a disadvantage? Or is it just different than what we're used to be doing? And maybe different isn't so bad, and maybe different can be changed in certain contexts. But as I think in the last decade since this article came out, really, I think we're seeing several changes take place. There's more technology in what we would call offline as well, right? So even when we're conducting just traditional ADR, there's much more technology involved than there used to be. Okay, so that's one thing. Second thing, I think, is our preferences regarding privacy have changed dramatically. If you think about people's habits online, Facebook, Twitter, whatever, the amount of information people just voluntarily disclose, and even if it is because they don't understand the implications of disclosing so much information, I think by now we're all much more aware. We understand that everywhere we speak, people are going to be taping us with their phones, right? Phones are computers. They're not phones. So everything can be on YouTube within seconds. Our employer is going to know what we think about them when we write it on Facebook, right? So many of the things eventually come out.
Yeah.
So over time, I think we view this as less catastrophic as we used to see it.
Right.
And we're going to have to assign less weight to these things when they do come out. So I think that's an inevitable development, even though in the meanwhile we're still kind of anguishing over the information that gets out. But over time, I think that's going to be another effect we will see. Yeah. And I think that over time we will also see technology much more present through hybrid processes. So again, that's going to increase the amount of information we actually have about mediations taking place, because some of it is going to be stored digitally automatically. So some of the points I raised in that piece, which I think are still true, are the significance of real-time information as opposed to information collected ex post.
Yeah. The
significance of follow-up, which has nothing to do with technology. And nowadays, almost no one goes back to people who have mediated 6 months later, a year later, and ask them what goes on. There's this truism that mediated agreements are more stable. There is some research out there that questions that, and I don't think we've done enough to follow up on that and learn.
Yeah.
Where it has been more stable, what has made it more stable? Again, learning and improving the field and improving the process and its outcomes. So that's not only the resolution rate, but do they stick, these resolutions? An important point. So real-time information, after-the-fact information over time, and caretakers of information, understanding that instead of making confidentiality sacred, let's make information about mediation sacred. We need to understand that someone has to follow up on this information, dissect it, understand what it means, and learn from it.
Yeah.
And think about, again, how do we aggregate? That's a really important point you raised. How do we aggregate information from the individual practitioner, from the individual ADR center, to something that's much broader and creates learning in the field as a whole?
Yeah. Then we can make better decisions and choices about which direction the field goes in, Right. I know this whole debate around evaluative mediation. Is it consistent with where does it fit in?
Right.
Then you've got the sort of transformative mediation, which I think is on the other sort of end of the spectrum, right. Really. And then facilitative seems to be, on a sliding scale.
Right.
And I think we can use data. At the moment, I get the impression that we've got evangelists in all different camps, but they're making voicing opinions or making choices and decisions not based on data, but just based on whim. And I think there is a big black hole of missing information that can help us move the field forward. And I've had a real privilege of being able to do all these interviews. I've got a real different perspective of mediation than I I did have a couple of years ago when I started, and it just seems I stand back and I speak to people like yourself and others, and I think it just seems to be a small minority of people concerned about the lack of rigor in mediation, both not just the training but the evaluation, the monitoring. It just seems to be a little bit, cowboy.
Yeah, I agree. And this was, this might have been appropriate in the early days, but I think we've grown. We're not even teenagers now. Mediation is middle-aged, right? And it should act that way.
Yeah.
So I completely agree. I think it's super important. I think many of the problems that we've seen with mediation programs on the ground have had to do with quality.
Yeah.
Certainly in Israel, I know that's true. And unless you incorporate effective quality control measures to ensure that the process is accountable, it's going to create more harm.
I always wonder, to what extent is the absence of this level of accountability and rigor holding back the field from is it that the general public have concerns about the field of mediation, the rigor and accountability, and that's why not more people are opting for it? Is it at some sort of psychoanalytic level that the mediation field as a whole isn't advancing forward because everyone's of the same opinion that, hold on, what we're doing behind closed doors, I'm not quite sure that I'd want other people to see me doing this.
Yeah.
So let's just keep it in this club for the time being. I don't know. It's really peculiar. When you every mediator that I speak to is an advocate of mediation, and every party that goes through the process appreciate it and feel like they have a voice. Yet it's only a minority of people take the opportunity, and it's just peculiar.
I think it's always difficult to change the way things are done, and there's something very strong about the training and the sort of practices that continue to be taught to people in the field, and I think very few people question them, and it's convenient to just follow the way things have been done. I think there's a huge opportunity for courts to require this. Most of ADR providers and mediators are desperate for cases. It's very easy to require them to meet certain quality control measures as a precondition to receiving cases, and maybe even the court should have a more active role in evaluating what takes place within, and not only encourage obviously internal monitoring, but also be more active in the external monitoring parts.
Yeah, and have you come across any examples in the offline mediation world where groups or organizations are endeavoring to improve accountability in mediation?
I think there are many groups thinking about these issues and are engaged in different types of models for doing that. I think a really impressive experience was the experience at redress. Redress is the system actually of transformative mediation, which is which is a very unique model of mediation, which I'm not sure would fit all people who are mediating, but is very powerful and interesting. A mediation school established by Bush and Folger, originally in '94, but developed a lot in the later years. And this model was chosen for the U.S. Postal Service's internal dispute resolution system for discrimination cases. And this system is pretty amazing. I mean, the USPS has 1 million employees, maybe over now, and this system was rolled out throughout the U.S., initially as a pilot, but later throughout the U.S. all with transformative mediators. Initially, they had internal mediators. Later, they had a different model where they employed external mediators who were trained by the USPS, by the unit in charge of the redress program. And I think it was a very interesting experience. I haven't followed the most recent writings on it, but Professor Lisa Bingham was really wonderful. Was a partner to this whole experience, and so from the get-go, there was academic research alongside the practice of mediation.
Okay.
And I have to say that the transformative folks themselves took this as a serious opportunity for them to rethink and to conceptualize what are their particular goals, what it means to be a transformative mediation, and how do we assess whether someone is actually a transformative mediation. So they actually had videos out there with transcripts where they highlight and demonstrate what is and what is not a transformative mediation. They created these hallmarks of what constitutes transformative mediation. They've made it a teachable school and one that you can actually evaluate and assess. You can disagree with it ideologically,
yes,
but they've made it very easy to understand, and I think relatively easy, not easy, it's never easy, but easier,
yes,
to discern whether someone is actually a competent transformative mediator or not. So, and they've really employed both qualitative and quantitative measures for doing that, handing out tens of thousands of questionnaires that measure procedural justice elements and whether the conduct is transformative or not.
Yeah.
And also they've had focus groups with different mediators discussing particular interventions. So they've had a whole host of measures put in, which I think is a super interesting example.
Yeah, because as you're talking now, I'm thinking about the idea of monitoring, because one of the things you talk about in your paper is real-time data, isn't it? And one of the lessons from ODI is the capacity of capturing, particularly in the square trade example,
right,
being able to capture the real-time data about decision points and so on. Thinking about bringing that into an offline setting, actually, one could have an observer or somebody even record that mediation, but just analyze the mediator's interventions and behavior to see to what extent they're acting consistent with the approach that they're espousing.
Right. So I think people have claimed that if you place a camera, then the parties would object or feel uncomfortable. I'm not sure to what extent this is still true.
Yeah.
Again, that's something, you could ask the parties. I wouldn't, and also here again, I think it's not an all or nothing issue. Even if you decide that twice a year you do that, or you don't even record, or maybe you just record voices. Of course, if the parties don't object, maybe they're more comfortable with that, okay? Yeah. You record the voices, or you just have an observer sit there and transcribe and write down the main interventions and then go over that with you. Someone who's very experienced and can do it well. We've done that in training all the time. Someone sits and writes something and talks to us about it, right? So, and it's better than nothing. Yeah. And even if you do it 2 or 3 times a year, it's very, very helpful, I think. So it doesn't have to be, obviously there are costs to having someone there all the time.
Yeah.
I'm not sure we want to do that. Yeah. And a co-mediator is not going to be able to perform that because they're doing something else. Yeah. It might help in other respects to ensure that someone doesn't do great harm, right? Yeah. But it's not going to do what we're talking about. Yeah. So I think there are many, many options, and we just need to be creative. First of all, we need to recognize the need for that, and then be creative in thinking about how we can actually generate real-time information, not always, not in every case, but in a sufficient number of cases to ensure that we actually learn and improve.
Yeah, okay, so that's the sort of real-time analysis, and I think we certainly in the United Kingdom, we'd need more sort of infrastructure in place to be able to implement something like that on a big scale, because there are just so many disparate groups, all sort of jostling for position, so that, and that's a real it's a chicken or the egg. It's a real chicken and egg scenario. It feels like certainly in the United Kingdom, so you also talked about sort of post-evaluation and following up with parties. What other accountability measures, if any, could we learn from the world of ODR and bring into offline?
I think we talk a lot about the flexibility of the process, which is a wonderful element of mediation. I think it is often less flexible than we would even like it to be, right? Because we've actually come accustomed to perform it in a certain way and reach typical results, and we're not always as creative and flexible as we would like it to be, but it's certainly an important element. I think without detracting from the process's flexibility, we can actually incorporate some consistency in our thinking about the process and how to perform it in a way that ensures appropriate mediator conduct, that ensures that issues don't get forgotten. So we could think of a list of questions that the mediator would go through before starting to work on an agreement, or before finalizing the mediation. So it doesn't even have to be a scheme that gives all the answers, but something that raises important points that we've found, after we've watched 10 mediations, we've seen that there's a problem that comes up. So we could actually try to make the practice more consistent in a way that we don't overlook certain problems.
Yeah, almost just like a pro forma for particular stages in the mediation process. Because actually, something else I picked up in your paper was, a mediator moving through the various phases of a process. The parties may not necessarily understand, where they are in the process.
Right. So we could use, for example, technology even for teaching purposes. So before someone comes in to a mediation, you could email them a link to a 5-minute presentation on what the process is, how it's going to be structured. Instead of talking on the phone, they can watch it when they want. They can stop in the middle. They can, they can do whatever they want. Maybe that's more effective. I'm not sure, but maybe.
Yeah, absolutely. Okay. Any other thoughts? How has your thinking moved on since that paper? Where are you now?
Well, I think it's unfortunately quality control is still a major issue in mediation. Again, I think technology is becoming more closely tied to traditional ADR, and over time it will become even more so. So I think that's actually a helpful point, but we need to think of technology, and that I think hasn't happened, to think of technology as a quality control enhancer, as something that can help us improve our practice offline. So again, we think of technology as relevant for ODR, but I think we should think of it in a broader sense, not just when we're online or conducting a process online, but how digitally stored data can help us improve our practice when we conduct it offline. So that's sort of I think a major challenge. But I think, the technology is there. We just need to be willing to use it. I think there should be more incentives to use it and to document data and to do stuff with the data. So, and I definitely think the justice system should play a major role, and make sure that it also can use technology to better enforce these preconditions to case referrals. Another layer of quality control, and then stop referring cases. If someone doesn't submit an extensive enough report that shows that they've studied what they've been doing and how they can improve, and they've highlighted where are the problematic areas that they've discerned, and actually not punish someone for uncovering problematic areas of practice. That's wonderful that they uncover everyone has problematic areas of practice, and the fact that they've been rigorous enough in uncovering these areas and are actually disclosing them, I think is something that should be praised and not punished, and is actually a good sign for someone who wants to refer cases to them.
So incentivizing reflective practice.
Certainly, that's a major part.
Yeah. My community mediation service that I volunteer at, they keep really good data on the cases over the course of the year. I mean, they have to because of the funding agreements that they have with the various authorities and charities and so on. So they monitor equal opportunities, data, number of cases that have been resolved, and so on. And I don't know that they keep a correlation between the cases resolved and who mediated. And I can imagine, going back to your conversation earlier about, anyone who's got a 90 to 95% success rate, be suspicious of. It's almost that bell curve. Anyone in the sweet spot, And
again, they may be just wonderful. But you may want to look at it.
Yeah.
So that's all I'm saying. You may want to, maybe that's someone you want to look at 5 cases a year, not 2, and just make sure everything's okay. Maybe you want to call up some of the people whose cases have been mediated before that person and ensure, what actually took place there.
Yeah. I'm on the assumption that they're obviously doing something really well.
Right.
What can we learn from it? That's that's the assumption.
Right.
I can just see now, mediators going out there and changing their success ratios, not to sort of 90%, 50 to 60%,
Exactly.
Just to conform,
But we have to recognize that, especially since mediators get cases from courts, there are significant pressures to reach a high resolution rate, and that's the danger.
Yeah.
And that's when people start getting more aggressive as mediators.
Yeah.
And that's a danger. And that's why I'm worried.
So the incentive is on the outcome rather than the process.
Yes, the courts definitely look at that.
Yeah.
When and that's also, that's an educational task.
Yes.
For judges and for court administrators, as well as us in the mediation field.
I did an interview with a chap a while back, and he talked about it's never been a more exciting time to be a mediator, and I feel like that. Speaking to you now, I'm just thinking there's a huge opportunity to really develop the field and transform mediation into something really rigorous, robust, consistent, that the people have a real trust in.
Yes, but without stifling creativity and flexibility. I think in many respects the answer to me when I think of mediation is very contextual.
Yeah.
It's different things are right for different people and different case types in different contexts. But again, we need to learn about that too. And to learn about that, we need to have people present and people reflect about what took place in the room, create knowledge, and share that knowledge. And that's also very, very important, to create a certain infrastructure of sharing knowledge and learning from that joint resource that can be created.
Yeah. Well, Orna, this has been a real eye-opener. Really, I'm feeling...
My pleasure.
I'm feeling really motivated to go out there and mediate and get someone sitting in on me. And I'm also interested in the redress program as well. So I interviewed Professor Folger a while back, but I might try and follow up with him, because I think
Lisa Bingham would be a great...
Lisa Bingham. Okay, I'll get in touch with her.
Okay, great. Okay,
Orna, listen, it's been lovely to see you again. Thank you ever so much for your time and your generosity. Have a great day, and maybe. Well, when's the book due to come out?
Oh, it'll take time, but hopefully October of 2015.
Okay, and do you have a working title for it?
Yes, Digital Justice by Ethan Catch and myself.
Digital Justice. Okay.
Yes.
All right. So if you're watching the interview, Digital Justice, keep your eyes peeled for that. It'll be a cracker.
Thank you.